Hello and welcome to Nessa's Law, and in this video we are going to see the steps which are involved in the formation of a valid contract. Now it is said that all the contracts are agreements, but not all agreements are contracts. That means in order to form a valid contract, the first step is the formation of an agreement. And that agreement is, again, it is not possible that all the agreements would take the form of a contract. Then what would be the essential conditions which would constitute or which would make an agreement into a contract, or which would convert an agreement into a contract? So in that sense, it is said that all the contracts are agreements, but not all agreements are contracts. Now, according to Indian Contract Act 1872, it defines that a contract is an agreement which is enforceable by law. Now the question arises that what is an agreement and what is that thing which makes an agreement enforceable by law? So answer to this question is given under section 10 of the Indian Contract Act, and it provides for the 5 conditions which makes an agreement enforceable by law or legally enforceable. So out of those 5 conditions, the first condition is that the parties who are entering into this agreement must have been entering voluntarily. That means their consent must be free. It must be free from the influence of fraud or coercion or undue influence or misrepresentation or mistake. Then the parties must be competent. Competent means they should be major and not minor. They should not be below 18 years of age, and they should be sound-minded persons. Thirdly, they should not be disqualified by any law in force. That means, for example, a person must not be an insolvent, because an insolvent person is not a person who is qualified to enter into a contract. Even an intoxicated person can be a competent party if, in case, although he is intoxicated, but when he is in senses, he has while entering into the contract, he was in senses. So in that case, that person can also be a competent party. Then lawful consideration. There has to be a lawful consideration with a lawful object. For example, if there's an agreement between A and B, and these two people agree. Now he says to this person B person says to A person, what he says that if you are going to kidnap the son of X, then I'm going to pay you 20 crore rupees. So in this case, is the object here a lawful object? Obviously it is not. So the object has to be lawful and the consideration has to be lawful. Now what is the considerations here? This person is saying that in case you are going to kidnap X's son, only then I'm going to pay you 20 crores of money, or 20 crore rupees. So these exchange of promises, they are itself they are the unlawful considerations, and therefore this is unlawful consideration. Then the terms of the agreement must not expressly be declared to be void. For example, they should not be forbidden by law or prohibited by law. They must not defeat the very objective of the law, or they should not be against public policy, or they should not be immoral, etc. And there are so many conditions which are given under section 23 of the Act, which we will be discussing in our later videos. Now the question comes is that what is an agreement? Now in order to understand an agreement, we need to understand what is a promise. Now, promise is again has to be dependent upon understanding of the terminology proposal. So first thing is, what is an agreement? Agreement is when every promise and every set of promises forming the consideration for each other is said to constitute an agreement. Let's take an example. Now suppose A is a person who is a proposer or an offerer. He is dealing with selling 200 books of or 200 contract books, and this person makes an offer to B person that whether this B person is interested in buying the books which are to be sold by him by A. So here this person, that means B person, who is a buyer, he agrees to buy these 200 contract books, say in amount rupees 20,000. So in this case, though like these two people, they have entered into the promises, and there might be some other conditions as well. For example, what would be the mode of payment, what would be the mode of delivery, what would be the date of delivering the books, by what date this contract has to be performed, and so many things. So these two persons must have agreed on several set of promises as well, apart from the main agreement. So in that sense, it is saying that every promise and every set of promises forming consideration for each other is an agreement. Now the question arises, what is a promise? Now in order to understand a promise, we need to understand what is a proposal. Because promise is something where when the proposal is accepted, it becomes a promise. So we need to understand what is a proposal. Now this proposal is not that Valentine's Day wala proposal. We are talking about transactions, that trade transactions, commercial transactions. So here it is saying that when one person signifies to another his willingness to do or to abstain from doing something with a view, why this person is signifying his willingness to another person, with a view to obtain the assent of this person to such act or subsistence, he is said to make a proposal. So for example, in my case, like the example which I have given just now, that this offerer or the proposer has made an offer to B person to sell his books, 200 books of contract to B at rupees 20,000. So this person, when he signifies to another. What is the meaning of signifying? Communication of the offer. Communication is something which is very, very important. So it has to be informed by the proposer that what he is intending to. Now the second terminology which is used here is the willingness. This willingness depicts the legal intention to enter into this agreement. So it is saying that when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain the assent of that other, is said to make a proposal. So in case of proposal, three terms have to be understood. That what is the meaning of signifying? Signifying means anything whenever is made, whether it is an acceptance or whether it is a proposal or an acceptance, they must be communicated. Without communication, it cannot turn into an agreement. Now the next step is, as I told you, what is a promise? That when this proposal is accepted, it becomes a promise. So as per section 2b, it says when the person to whom the proposal is made, in my example, this B was the person to whom A made a proposal. So he is that person to whom. When the person to whom the proposal is made, he signifies his assent. Now the next step after the offer or the proposal is that this task has to be done by this second person. Now when this person to whom the proposal is made, he signifies his assent thereto, then this proposal, when accepted, becomes a promise. And what is an agreement? Agreement is every promise and every set of promises forming the consideration for each other. And when this agreement is enforceable by law, it becomes a contract. So you can see that the stages of constituting a valid contract starts from the offer. So there has to be an offer, and once it is accepted, it becomes a promise. And when there is every promise and every set of promises, they are forming part of the consideration, it becomes an agreement. And if this agreement is enforceable by law as per section 10 and many other conditions which we will be discussing in our later videos, it will become a contract. I hope you could understand the formation of a contract through this video. Thank you so much for watching this video.